Good morning, Judge.
Hi there. Not quite yet.
Okay.
Let's make sure we're officially starting and then yes. Let me know when you're ready to go.
Just need about 2 minutes.
Okay.
Ready?
Good. Okay. Then let's get on the record. This is 23 SC 190102, State versus Kenneth Poole. Mr. Poole is here. How you doing, Mr. Poole? Good to see you again. Mr. Poole, you are here with Mr. Miller, and I need to know who else is sitting at the table with you.
Well, Your Honor, this is DeAndre Berg, Chief Co-Counsel on this.
Great. Can you say your last name again?
Bird, BYRD.
BYRD. Great.
I filed my entry of appearance yesterday.
All right, well, welcome aboard. And Ms. Byrd, will you be here for the duration or are you a jury selection expert?
I'll be here for the duration.
All right, so Miller and Byrd for Mr. Poole, and then we've got Mr. Abadi and Mr. Rao. Gentlemen, good morning. Mr. Rao, will you be doing the whole trial with Mr. Abadi or just today? Trial, all right. Then we've got our lawyers. Mr. Abadi, is the state ready to go forward?
Yes, Your Honor.
And Mr. Miller, is the defense ready to go forward?
Yes.
Okay, then Ms. Rios, you are free to go. Thanks for being here. I know there are a bunch of things we need to talk about, but I'm going to have Ms. Nelson order up the jurors. There are a bunch of trials starting. We want to get in line so we get jurors sooner this morning rather than later. So Ms. Nelson, if you would do that, please. Mr. Abadi, is there an offer that Mr. Poole could consider that we should get on the record so that there's no confusion after trial if this time the jury comes back with a guilty verdict?
The last offer that I relayed to the council was that I would dismiss the felony murder counts, complete the vehicular manslaughter counts, and the remainder of the indictment, and then he could go up non-negotiated and ask the court for whatever sentence he believed was appropriate.
Okay, and no mandatory minimum if you remove the felony murder counts.
That's right.
Okay. Mr. Poole, do you understand that if you decided you wanted to enter a guilty plea in this case, which you're under no obligation to do, if you did, the state would dismiss the 2 felony murder counts. Those are the ones with the mandatory sentence of life. And you would be entering a plea to the 2 counts of vehicular homicide and the 1 count of fleeing or attempting to elude a police officer with no agreed upon, hey, everyone's going to recommend X. The state would recommend what they think is a reasonable sentence, and Mr. Miller would be able to argue for what he thinks is a reasonable sentence. So he'd be free to go in the direction he sees fit. Do you understand that?
Well, Your Honor, it wasn't put to us that way. I haven't had a chance to discuss that with them. I don't believe I received the felony murder was going to be dismissed. So I haven't had that conversation with Mr.
Okay. So you heard what I heard, though. That's the state's offer right now. You and Ms. Byrd and Mr. Poole can be talking. We're going to press forward, but you guys should marinate on that. Is there, Mr. Abate, a point at which that offer is being withdrawn?
At the time of opening.
Okay. All right. Mr. Miller, anything more you want to get on the record as to what the offer is and its expiration?
No, Your Honor, I would just like the opportunity to explain all of that.
Sure. You'll have that. It sounds like the offer is good through tomorrow morning, which is when we would do openings. I've got the indictment, and I have a copy of the indictment. Mr. Miller, do you waive any issue of proceeding with a copy of the indictment rather than the original? Have you and your client sign it with a not guilty plea, et cetera, with today's date, so it's fresh? Are you all right with that?
No,
Okay. Mr. Abadi, if we go forward with trial, how long do you think the state's presentation will go?
I would say into probably lunchtime Wednesday.
Okay, and no drug court this week. We've got just this 9 to 5 each day. So if openings are tomorrow morning, you think you would be resting at some point on Wednesday?
Yes, sir.
Okay. Mr. Miller, your thought about the length of the defense case?
it would probably be, if they rest lunchtime, I would say probably be Friday afternoon.
Okay, so a couple days for the defense case.
Yes, sir.
All right. I will qualify the jurors through next week. I am out Monday and Tuesday of next week, running a training thing. And so we wouldn't be able to reconvene, whether it's to finish the defense case, a rebuttal from the state, closings, et cetera, until Wednesday, the 10th. So we'll need jurors who are available for a couple days next week as well, given your estimates. I need, at some point before we do voir dire, the latest witness list from both sides. They've been kind of shrinking and growing, and when I was looking in the docket, there are a bunch of supplemental witness lists. I need the whole thing from both sides so that I can be asking the potential jurors about who they know and who they don't.
Mr. Poole signed as the ADA. Do you want us to just mark it out, initial it, or you want to print a new copy?
We don't need to print a new copy. He can either mark it out, or you can just do the next column over and strike through everything. There's 3 signing blocks. Thank you. I sent to you all a little before Thanksgiving, the voir dire, which was basically cribbed from what we did last time. Does the state have any additions or deletions to the proposed voir dire?
Hang on.
Mr. Miller?
We want to look at, I did not.
How long have you been back, Mr. Rao?
Couple weeks.
Couple weeks?
Weeks.
Everything good at home?
He's great. Thank you, Russ.
Are both of you back or just you?
Just
Yeah. No objection, Your Honor. I'm guessing that, are you related? You're going to add Mr. Rouse as well as,
And Ms. Berg, yep, I just didn't know who would be at the table with the 2 sides. So I'll be inquiring as to both prosecutors, then also as to you, Ms. Berg, along with you. Okay.
How soon would you need that consolidated list?
Well, the jurors are supposed to be here in about 20 minutes if everything goes smoothly. And part of what I ask them is, do you know any of these names? Because these are possible witnesses. I'm fine if you write it on a piece of paper. As long as I can read it, I just need to be reading it to them. Okay? And then, Mr. Miller, I assume you remember, it was a while ago when we had trial, but the flow will be, all 51 jurors will be out there. I'll ask the general questions. We break them into 3 groups of 17. And state goes first with the first group. You'll go first with the second group. I let people go for the day after both sides have done their individualized questioning so that when it comes time to exercise strikes, there are no jurors sitting around. It's just us. And we will not break for lunch. We'll take a break between the panels, 10, 15 minutes, but there won't be a, hey, let's break for an hour.
Would be like a 15-minute break. I've been having issues all weekend I haven't had anything to eat.
Okay.
So I might start. I just need to change to get.
So two things. One, anytime we need to take a break, we should take a break for your well-being or anyone else's. Two, yes, between panels, there's a break of 10 or 15 minutes. You can eat whatever during that window. But like I said, if we need to pause at some point because you're fading or you got to get a granola bar, that's not an issue. Okay. We need to talk about how the lawyers are going to refer to the fact that we had a trial before in a way that doesn't refer to the fact that we had a trial before. I suggest if you're asking witnesses or talking with the jury that you talk about earlier proceedings or other proceedings, but it will be very natural if a witness comes in here and says something pretty different than from last time that you want to talk to them about. Well, you've testified before in connection with this case, but I want to make sure that one, the two sides have instructed their witnesses to not say, yeah, at the trial before where there was a hung jury or whatever might come out of their mouths. And if you need to lead them through that process, even though it's a witness you've called, I'm fine with that. But if we can agree on an approach to managing that, that would be good. Mr. Abadi, do you have any preferences to how that goes?
The court said, either lead or have instructed my witnesses that anytime they questions asked, I would reference it as a previous hearing or a prior hearing involving this case. So I'll re-instruct all of the witnesses prior to their testimony.
Okay. All right, Mr. Miller, your thoughts?
We've done the same, refer to it as a previous hearing.
Great. Okay, then you are also free to ask people, well, you've testified before in connection with this case, but it needs to be, and the jurors aren't dummies, they may figure it out, but we don't need to put it on a plate in front of them that it was a trial rather than a suppression hearing or who knows what. They may just be thinking that we had a pretrial hearing or whatever we did. 1 second. Okay, well, that was easy. We will work hard to toe the line on that. The only motion I found in the docket that is new relates to, I don't know how you pronounce his name, Dr. Brogy or Broggy? Brogy, Dr. Brogy. Mr. Miller has filed a motion seeking to exclude Dr. Brogy, and we can start talking about that in the time we have before the jurors get here. I don't think that's anything that will come up today anyway, other than that I would say his name as a potential witness, but I don't think that generates any of the harm that Mr. Miller was concerned about in his motion. So Mr. Miller, I will start with you. If you want to tell me if there's anything you want, I read your motion, I understand your concerns. But if you want to get them more on the record today, you are free to do so. Adam.
Sure, Your Honor. The bench objects to the rebuttal witness that the state filed late Friday afternoon, and Dr. Matthew Brody.
So let's get clear about the dates. I'm assuming it wasn't Friday, the 28th of November.
That would have been Friday, the 21st.
Okay.
Of November, just prior to the Thanksgiving holiday, as well as the Black Friday holiday that follows afterwards. And so he's a former deliberating juror from the prior trial. Same defendant. His proposed testimony is, we believe, is inadmissible as a matter of law and as well as constitutional fairness. First of all, under OCGA 24-6-606B, Jury deliberations are privileged testimonies inherently intertwined with the prior deliberations. Our testimony or our findings that it would be nearly impossible for Dr. Brody to exclude what he has already seen and experienced as a former juror in the last trial. And as such should be excluded for that.
Let me explore that part with you. Dr. Brogy could have sat in court and watched the entire trial. I'm separating out the deliberation piece because I think that's the nugget we need to work through. But in terms of watching the trial, witness testimony, video evidence, your client's testimony, et cetera, Dr. Brogy or anyone else could have sat in trial and watched it, or it's live stream, they watch that. Nothing improper about that, consuming a public proceeding. Does watching the trial mean you couldn't then be a witness in a retrial?
That part would be, I would say watching it, no. But being that you would have insight as to what the jurors are thinking and what the jurors are deliberating in the room and what nuggets that the jurors are looking for and were unable to get, that is the part where his testimony would put him as basically a super expert in a position that no other expert would be able to be in because he has that insight.
What would be different from the state hiring a medical professional and that medical professional reaching out? The identity of the jurors from the first trial are known to the state. And so they hire an expert, John Doe, and a medical expert. And John Doe's kind of curious, having looked at the information, well, why wouldn't jurors have found it incredible to believe that someone could go from the back seat to the front seat in the car? That's his perspective. That I think the way the car works and the body works, it's physically not possible for someone to have gotten from the back to the front and not sustained certain injuries that your client did not sustain. I'm curious about that. I'm gonna go talk with the jurors, and the jurors agree to talk to him. Could he then not testify? He couldn't testify, hey, I talked with the jurors and they told me, well, I didn't believe the state trooper, or Mr. Miller gave a persuasive closing argument. That would be hearsay and whatnot. But would the medical professional, is there something that prohibits him from interviewing jurors to say, well, tell me what you struggled with? And using that knowledge to then tailor his presentation to the next jury.
I would say yes, because at that point, that individual is not basing their opinion they're not basing their opinion on the science, which is what this expert should be basing it on. Instead, they're tailoring it towards the opinions of the jurors that were already inside deliberating.
Well, jurors from the previous trial, we'll have 12 new, I can promise you one thing, we won't have any jurors from the previous trial as jurors here. We may have one as a witness, but we won't have any as jurors. So it's a clean slate, it's different people. But this expert, in my hypothetical, because I'm wrestling with this as well, I'm trying to figure out the contours of the issues. And the example I came up with is this: they hire an expert who wasn't a juror, but he's just puzzled. How could the jurors have come up with this way? Can I go talk to them? And the state says, sure, if they're willing to talk to you, you can't coerce them. He calls them, yeah, sure, I'll talk to you. Here was my concern, or here's what I thought. There's that space between the seats. And if you hit the wall at an angle because it was the right front fender that really got crushed, you just slide right through and then you'd be in the front. And so this expert is learning how lay people thought about a situation about which there was precious little testimony. Neither side presented much in terms of an expert saying, here's how a body could or couldn't move from the back seat to the front seat. There was focus on oil in the eyes, what you could recall, the trooper's credibility, et cetera, et cetera. But I couldn't think of why you would be able to disqualify an expert who shared that part of the work he did was talk with the jurors from the first trial.
Well, he wouldn't be able to share that in the new trial. And if his basis of his opinion is off of whatever those jurors discussed with him instead of the scientific methods and whatever it is that his expertise is in, then he wouldn't even be qualified as an expert at that.
Well, two different things. One, I agree with you. He couldn't say, and I talked with jurors and they told me X. But I hope that's not what the state's trying to do, is to have him talk about the deliberations. I suspect not. But the second, you have assumed, I don't know what Dr. Bogey's going to say, but you've assumed that he's going to abandon science and focus on whatever jurors may have been talking about. And I didn't get that from the notice, and I agree with you. If you were able to establish, and it may be something we do outside the presence of the jury, that, well, I'm basing my opinion that X, there's no way a body could have moved from the back seat to the front seat based on things jurors told me. Well, that's not science. I suspect that's not the basis of his opinion, but I don't know. And you're entitled to learn more about that. So we need to get the doctor in here during a lunch break or when we're done for the day or something like that. But assume with me for a moment that the basis for his opinion is whatever he'll articulate about human physiology and the flexibility of bones and what happens upon impact. I mean, things that you and I might not naturally understand. That's the basis of his opinion.
So I don't believe it's possible as a person, we're all human. We are our experiences, we are what we've gone through. Part of the reason why I act the way I do is because of my mother and my father, the influence my little sister has had on me and my brother. It would be impossible for him, who's someone who has already experienced this trial, has already gone through deliberations, has already formed an opinion on Mr. Poole, and yes, by the side that he's testifying for, we all know which side, which opinion he has. It would be impossible for him to separate his previous experience with his already, an opinion that he's already formed. And that opinion was formed prior to him telling them whatever he has told them already. And so because of that, he can't now say that, and there is, if he wants to say that, then there are.
He wants to say what?
If he wants to say that, like Your Honor is saying, that this is based purely on expert, whatever. On cross-examination, I should be able to explore those biases. And the biggest bias would be the fact that you've already heard all this evidence. You've already formed an opinion on my client. You were unable to convince 11 other jurors at a previous trial. And now you want to convince 12 new jurors. And because I'm unable to explore that bias.
Why are you unable to explore it? I don't think the state can open that door. Why would you be? What objection could the state make if you decided you want to do that I would sustain?
I think 606B, going into jury deliberations and what happened during jury deliberations prohibits me from exploring that bias that he would have. And because of that, it's inherently is unfair, because the biggest thing, the biggest issue with him is the fact that he was a sitting juror and very unable to hear it. Yeah, he wasn't watching the trial as a bystander. He was part of the trial. He spent hours. He's already formed an opinion based on the evidence at the last trial. And so trying to say now I'm an expert and this is what my opinion is, I can't explore that bias.
So I follow the thinking, but if Dr. Broggie says, yeah, I formed an opinion because I am a doctor and I know how the body works, and it's the only way, if a body had been in the back seat in a car going that fast that had the sudden impact it had, for it to end up in the front seat, I would have found 8 body parts and not a whole body. I'm making this up. I don't know what he's going to say, but he'd say the only way for a body to pass from the back seat to the front seat would be for it to separate into multiple parts. And I knew that the moment I saw those pictures. I knew that blah, 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 blah. then his opinion isn't formed in the crucible of the deliberations. It's formed because he knows some things about the body and impact and whatnot that you and I don't. And if his testimony is, that was my belief as I began to receive the facts in the case, it was my belief during deliberations, query whether we need to talk with this jury about that. And it remains my belief because that's, I'm gonna pretend it's the physics. That's the physics. The only way for a body to get from the back seat to the front seat in that car with those dimensions at that speed would be for it to break into several pieces. And Mr. Poole had all his limbs attached to him. And so scientifically, I'm telling you, it is implausible, improbable, maybe he won't say impossible, for him to have been in the back seat and ended up where he was found. Full stop.
Right.
That's his expert testimony. And assume for a minute, I don't know, if he's a podiatrist, then it's probably not the right person. But let's assume that he's qualified to say those things. What's the 606B issue around that?
He goes towards the cross-examination. He can say that all day,
Mhm.
that's fine. But the jury should be able to explore the weight of his opinion and the weight of, the bias that he has. And the jury is unable to hear the complete story of who this person is because of the previous case.
If the state waives any 606B objections, then what is the harm or the disability that you face in terms of a thorough and sifting examination of the witness?
If they waive that, which,
I mean, that might be the price of admission. I don't know. Like I said, I'm working through it.
if they do, then the next issue would be the extreme unfairness and the structural unfairness under due process, because one of the issues is we've known about this trial coming up for a while. Our office filed our and so I don't want to get these dates wrong, because that's where it comes from. What we've done is they asked for a continue. They actually had a motion for continuance with respect to the November 5th, 2024 trial. So shortly after this trial in August, we were getting prepped for this trial again in November. They filed for a continuance because we had sent notice of our expert opinion, our expert witness. They filed for it based upon that. And so since then, they've known that we've had this expert that was hired, not hired, but that he was there. On May 30th, we were set on a 2-week trial calendar. My office was prepared. I prepared for this.
This is May 30th of 2025.
2024. Well, this is going back to 24 when they asked for their first continuance in May 30th. And that was on the record on 2-week trial calendar. On June 5th, they requested a continuance by email because something about due to have incorrect information regarding the witness's availability.
So I want the record to be clear. May 30th of 2024. I don't know if that was before we had our trial.
Right, correct.
So our trial, I declared the mistrial on September 3rd, 2024. So we should talk about events post September 2024. And I've got in the docket exactly what you said, which is we were going to maybe go to trial in November of last year, so a year ago. And then the state on November 1st requested a continuance. You objected, but I entered an order granting the continuance on November 5th of 2024. I think this is, let me look at this special setting date. I specially set the case for today at the end of August. So we had one other in November of last year. Maybe we were going to try it. And there was a motion for continuance. I granted that. And since then, it hasn't been a false start of, hey, everyone get ready. I specially said it after conferring with you and with Mr. Abate, because I think I had put this on what we call our consolidated calendar that a senior judge handles. And both of you, meaning state and defense, but I'm recalling you in particular, Mr. Miller said, look, my client's from Tennessee, but a bunch of the witnesses are from Tennessee. A date certain is really, really helpful. And so I said, fair enough. At the end of December 1's our day. Here we are.
Right, but there's 2 days prior to that. So there was the February, and I don't remember the date. I think the solid date might have been December, but there was also the February date in which we were getting ready, and that's when we disclosed Dr. Kimes at that time.
Okay.
When Dr. Kimes was disclosed, Your Honor gave him a continuance because we disclosed him 10 days prior, so that they could get rebuttal witnesses in case they need to get it.
Okay.
There was another date, and I can't remember that one, but it was in between February and August when we went to court. And on that time is when we disclosed, what is her name? The ER nurse, Dr. Or Miss.
See, on August 1, Richard Freeman.
Right, correct. Her. And at that time, Your Honor, like, they're not gonna be, you just disclosed this, they're not gonna be ready. We were granted another continuance. And so the fairness of it is we disclosed our people 10 days prior, even though statute says we only have to disclose them 5. They're granted continuances so that they can get somebody to rebut these and the people that we disclose. And then on literally the week before Thanksgiving, knowing that I have LOA in that week, they disclosed somebody, and it's not like they said, oh yeah, this is a previous juror. I had to do my own digging to find that individual. And out of the hundreds of orthopedic doctors that are in this metro Atlanta, out of the thousands that are in the state, the only one that they can find is one that was a previous juror. It doesn't pass the smell test. Besides that, Your Honor, it's like if I wanted to get somebody to rebut that, I don't have enough time to do that because everything shuts down around this time period because it's the holidays. And so I couldn't come up to the court to even verify to make sure that this was a juror prior to it because I was scheduled to be out of the town. I had to cut that trip short because of the trial, but we couldn't even get the actual juror list. So we had to rely on our notes and just memory to even come up with the fact, oh, this guy was a previous juror. And so it has bad faith written all over it because if you knew about everyone that we had disclosed months in advance and you knew about this juror a year in advance, why would you wait till everything is closed and Mr. Miller has his LOA in before you file notice of this person? And don't tell anybody that it's a previous juror, but just put it out there and then let us try to figure it out.
Got it. So you have 606B concerns, which might be resolved depending on how the state wants to approach this. You've got, I'll call it fundamental fairness concerns because of the late disclosure coupled with in the past, when you disclose someone close to trial, the state asked for a continuance and I granted it. Now, are you asking for a continuance? Or are you saying, I don't want a continuance, but I also want this guy excluded because of, I'm going to say late loosely. I have to do the math if it's 10 days or not, but it's certainly close in time to trial. And there's that, I'll call it more fundamental piece of it's just peculiar. I don't mean that in a negative way. I'm going to hear from the state in a minute, but it's a strange set of facts that this is a former juror. If this were just Dr. Brogy, who they happened to come across because in the prosecuting attorneys council website chat group, they say, hey, a real good guy about what happens to bodies in cars when there's a collision is Brogy. You should reach out to him. That's a different backstory from this is a guy who was a juror.
Right, and so asking for, if he is allowed to be a witness, one, as Your Honor has wrestled with this, I've also, initially, of course, what do? You can't do that. But looking at the case law, there is none. Looking at the statute, it doesn't directly address this. And so if he is allowed to testify, I would ask for a certificate of immediate review because I don't believe he should be able to. And every single attorney, ADA, actual DA that I've talked to is like, you can't do that. Not only you can't do that, Your Honor, when I was a DA, one thing that I learned and one thing, the way that I was trained was that just because you can do something doesn't mean that you should. And this is one of those circumstances where, no, we don't have rules that say that you can't specifically have this done, but you know what I mean? Like, it's just like, why?
I kind of do, but did you press any of these people who say you can't do that to say, tell me why you think they can't do it? Because I would like to be ready to argue it to a judge. So give me a statute, give me a case, give me something. And what it sounds like is it's more of a just instinctive reaction, like people might say, you can't let jurors ask questions. Oh, but you can. And that's all right. And the Supreme Court has said it's all right. There's no rule anywhere that says jurors can ask questions. But if done correctly, the Supreme Court has said, you know, jurors can ask questions during trial. I will tell you, many of my colleagues have looked at me like I've got a third horn. You do what? That corrupts the process. Jurors are not fact finders. They are empty vessels filled by the lawyers. That is a perspective. I respect it, not my perspective. So I'm not disagreeing with you that a lot of people have a reaction of, what? That's kooky. Well, so was the notion of you can fly. What do you have concrete from these people, DA, ADA, lawyers, fancy lawyers, not fancy lawyers, beyond them saying, that's just not right?
Yeah, well, that's the thing, Your Honor. With respect to jurors asking questions, there's case law that allows that.
There is now.
Yeah,
Okay.
there's nothing here.
Okay. But it starts somewhere. And I'm curious what beyond it feeling not right to the people you've canvassed, you heard. I guess you shared with me, like 606B is sort of a toehold, but that might go away if the state says, we're not going to prevent Mr. Miller from exploring that with Dr. Brogy, because you should be able to. He doesn't just come in here as, all I've done is read the documents.
Yeah, but we've already established before we started this motion that we would refer to it, the last trial, as a previous hearing with all of the witnesses. And so now when I'm on cross-examination with him, I'm saying that the last trial, you were a juror. And so the jury's going to hear that. There's no way for them to not hear that. And they're going to give him, or it is possible that because they are aware that he's a juror and that he is so gung-ho on coming back to court and testifying against Mr. Poole, that his testimony is going to have greater weight than anybody, any other expert, any other witness that was here, because he could be seen as quote unquote so passionate about this case and all of his findings within them. But no, I would say that everybody's instinctive, I would agree, is you can't do that. But there's nothing saying, you know, the back and forth that I've had with everybody is similar to what we're having here.
Okay.
There's nothing concrete saying that you can't do this. So it comes back to, just because you can do it doesn't mean that you should.
Okay. Last question, and then I'll hear from the state. Tell me what is prejudicial to your case if this jury learns that there was a previous trial?
If the jury learns that there's a previous trial.
How is that bad for you or for Mr. Poole?
Well, not only was there a previous trial and we had a hung jury, but there was, how it's prejudicial is that there was a previous trial and, are you talking just previous trial in general or a previous trial and then he's testifying? So I know how to.
So my question is, once you confer with co-counsel, and then I'll tell you my question. Well, I'll tell you my question, then you can confer. you raised a point I hadn't thought of, which is, well, if I want to be able to thoroughly cross-examine him about his origin story, because he's not just a doctor off the shelf, he was a former juror, I am revealing to this jury that there was a trial before. And as you pointed out, we just finished a discussion about let's not tell this jury that there was a trial before. Let's talk about a prior hearing, a prior this or that. But that got me thinking, well, why do we care that the jury learns that there was a prior trial? And sometimes it's very different depending on the side of the V you're on. So I'm less interested in the state's perspective on that right now. But you raised that as this would be bad, Judge. I'd have to let the jury, in order to cross-examine this guy the way I should, and I agree with you, the jury's going to learn there was a trial before. And then my question is, so what?
So there was a previous trial. At that trial, they will know that it wasn't a guilty verdict because you're back here again.
Do they know it wasn't a guilty verdict, and then there was an appeal, and it was a successful appeal? We certainly wouldn't get into why are we trying it again, but this is why I'm pressing you on it, because these aren't lawyers necessarily. They might think there was an acquittal and the state appealed the acquittal. Can't do that. And the higher court said, oh, Miller and McBurney made mistakes. The state gets a second bite at the apple. They might think that it was a conviction and it got tossed. They might think hung jury. They can think lots of things. We don't go to why there is a second trial. It's not what would be explored. In some ways, this wouldn't be the right juror anyway. Like he's the right person. He just knows he's here to testify. So keep going.
Right. So it would be specifically on that. It would be the fact that we're back, and so the state is still pushing the button on this case. They are still pursuing it and trying to go after Mr. Poole. And so there would be a question of the jury of like, they keep on trying to go after this. They're not giving up on it. Maybe there is something there. And so that's where the prejudice. He is going to be he's going to be somebody that's going to have that insight. I'm sorry, Governor. Right, and there's no other witness that would pose that threat that would bring up, the fact that there was another trial and that the state keeps wanting to fight the hassle.
Right, at least purposefully, correct. I mean, your witness could inadvertently spill the beans and say, well, at the last trial I said, and then we'll have to work through that. But this is one where you've explained, well, no, I would want to pierce that barrier that we're constructing. So that the jury knows more about this guy, that maybe he isn't a neutral person because he was part of a jury and here we are again, and now he's talking about some technical things. So I understand why you'd want to explore with him that he had been a juror before, which undoes this protective effort of let's not let this new jury know there was a prior trial, which led to my question, which is, well, why? I just sort of assume no one wants to talk about the fact that there was a prior trial, but maybe that doesn't matter. But you've articulated that it in theory could create the sense amongst the jurors that, well, Mr. Poole must be a bad guy because here the state's trying again. And if he was a good guy, they would give up after the first one. I don't know that's a super compelling argument, but I get it. I just struggled to come up with a compelling argument as to why it's disadvantageous to the defense for the jury number 2 to learn that there had been a jury number 1. Other than it's not relevant.
All right. Okay. Yeah. And so that Ms. Bird's point, it kind of follows what Your Honor is saying, that like witnesses, I mean, the jury, they're all like, and so the opinion, the thoughts that they're gonna have when they hear about this other trial, they could go either way. But we shouldn't even put them in that position where where we have to decipher if they're going to be more pro Mr. Poole based off of this witness or pro state based off the fact that they keep biting the apple. It's a position that no juror has been in before, or that we know of, because there's no case law on it. But it's also one that not only is unfair to Mr. Poole, it's unfair to the jury, it's unfair to the whole, where's the lady of justice at around here? Like, that's why we have this here. It's because it puts the jury in a bad position, because now they have to decipher between that. Why should we care that Mr. Poole is here again?
Okay. Let me hear from the state and then I'll circle back to you. Mr. Rao, you're standing up reluctantly. You're going to argue this?
Yeah.
Okay.
So I'm not aware of any legal precedent that would preclude Dr. Brody from testifying. I don't believe Rule 606A or B theoretically applies in this particular case. And the bias that what I believe the defense is postulating to the court is the fact that Dr. Brody had an opportunity to sit through all the evidence and form an opinion based on sitting through and hearing all that evidence, and then deliberating with other individuals in the jury. From my perspective, I think the deliberations that he had with the other juries are of no legal consequence as it relates to testimony, any more than it would be if Dr. Brody was not a member of the jury, but had an opportunity to sit through the trial and discuss it with other experts in his field. And let's say 10 of the other experts came to the same conclusion, one expert did not. It doesn't have any legal relevance as it relates to his testimony. So I'm not aware of any precedents or case law statute that would preclude him from that perspective.
What's he going to say?
He's going to say, based off his a review of the medical records, the autopsy reports, that it's injuries that Mr. Poole sustained are more consistent with that of having been in the driver's seat. The Mr. Minor's injuries are highly inconsistent with the injuries of the driver, essentially. And that's based off.
And remind me, there's a second victim, his injuries, no one's disputing he was not the driver, or?
From my review of the last trial, I don't believe that's the defense's position.
It's Minor or Poole who's behind the wheel.
Correct.
Okay, so person number 3, we don't get into what his injuries indicate about where he was in the car.
Correct.
Okay.
And in addition to the review of the medical records, obviously his expertise as an orthopedic surgeon, having worked at Grady specifically as it relates to forming trauma care on patients, would be the basis of his testimony. The bias that's being postulated to the court is the fact that he had access to the evidence, no different than any other expert who did not sit on a jury or sit on the trial and formed an opinion based on the evidence.
Except that this particular expert actually sat with all the jurors and debated with them. How do you guard against, is there even a way to guard against, or option C, does one need to guard against whatever was learned, imparted, gathered from the deliberations, which is different from consulting the medical textbooks or talking to colleagues?
I don't believe it's relevant as it relates to this particular trial. Any opinions that other people had as it relates to listening to the same evidence that Dr. Brody did isn't relevant. What's relevant is what Dr. Brody had access to as it relates to the evidence in this particular case, the same evidence that everyone else had access to in the last trial, and forming an opinion based on that evidence. And again, the purpose of Dr. Brody's testimony isn't to be, yeah, I sat on this jury, my position was clear. Maybe someone else's position wasn't as clear. And that's why I'm testifying here. I'm an expert in this particular field. I had access to this particular pieces of information and evidence. And based on that, this is my opinion.
Any reason, unless his opinion is way out in left field, you all didn't after having heard from him or whatever the process was, you didn't reach out to another orthopedic expert to avoid the structural baggage he brings with him?
There wasn't a belief that there was structural baggage as it relates to prior jury service. Again, from the perspective, there's no case law to support any preclusion of his testimony as it relates to an expert witness in the field of orthopedic surgery. The conversations that he had with other jurors are of no legal consequence. There was no verdict rendered. It's as if we started back to square one. And the fact that he had conversations with other people based on his review of the evidence, no different than he would have been in the same position to do if there was never a previous trial when we were trying this case for the first time. If he had conversations with his spouse, with his children, with other experts in the field, or just friends and colleagues, it would be no different as it relates to his testimony in that regard.
If he testifies and Mr. Miller or Ms. Bird wants to explore the fact that he was a juror in this case before and go wherever they think that might take them, do you envision imposing a 606B objection?
I think that would be appropriate, given that any conversations that he had with those previous jurors aren't relevant as it relates to his testimony.
So let me ask it differently. First, if I'm going to pretend Mr. Miller's doing the cross, but it could be either one of the lawyers. His first question is, Dr. Broggie, you were a juror on the first trial of this case, weren't you? Are you objecting or not objecting to that question?
I think a 401 objection would be appropriate.
Why shouldn't Mr. Miller be able to explore that experience as a potential source of bias for Dr. Broggie? You didn't like the way my client testified, did you? You felt like he wasn't respectful of the prosecutor. I know what Dr. Broggie's going to say, but shouldn't Mr. Miller be able to explore that? Because Dr. Broggie's not a stranger to the case. It would be a bizarre question if Dr. Broggie just was a Grady physician and he looked at the materials and then Mr. Miller starts, you don't like my client, do you? I would think you would object and I would shut that down. But that's not who Dr. Broggie is in connection with this case.
I mean, I guess one way to skirt around it, if we want to avoid mentioning a previous trial, is you observed a previous hearing and developed an opinion based on that you don't like my client, or something to that effect. Maybe that could potentially overcome the 401 objection by the state, but I don't think the fact that there was a previous trial and he was a juror in that particular trial is particularly relevant as it relates to his testimony. Again, I've not heard anything to say that the bias that Dr. Broggie hypothetically has in this case is based on anything other than the fact that he had access to the evidence, same as the defense's experts. I understand there's a small caveat in the fact that Dr. Broggie was a juror in this particular case.
Or big caveat, but that distinguishes him from a defense medical expert.
But not to the point where I believe that there's a preclusion of his testimony and that there needs to be any mention that he was a previous juror. His opinion is his opinion.
Okay. Thank you. Mr. Miller, question, and then I'm happy to hear any response you've got to what you heard from the state. Do you have there've been a number of names that you've added over time to your witness list, several of whom are experts. Are any of your experts people who you expect will opine on the nature of the injuries and the consistency of those injuries with being, well, let's start with Mr. Minor. Are any of your experts going to say, actually, the injuries Mr. Minor sustained are not inconsistent with having been the driver? That's sort of the easiest, loosest conclusion someone could make.
Are any of my experts going to say that his injuries are not consistent with him?
Not inconsistent, not inconsistent. That is a super conservative expert opinion. Someone would say, I'm not saying he was in the driver's seat, but those injuries are not inconsistent. If his only injury was he broke his right arm, and an expert would say that's inconsistent with being the driver. You'd have something on your chest. But an expert could come in and say his injuries are not inconsistent with being in the driver's seat. Better for you is an expert who's going to say they're consistent with being in the driver's seat. You can answer either one of those. Do you have a medical expert who's going to come in, basically the impact of his or her testimony will be minor was in the driver's seat?
Yes.
Okay. So this is the state's rebuttal expert. Why do we have to give you a ton of time to get a rebuttal expert?
Well, specifically for this expert, like the state, jurors have reached out to my office. One in particular, which is why when I saw Dr. Brogy's picture, it clicked so quickly. One in particular said that she was one of the holdouts and that he specifically during the deliberations was who she was bumping heads with. They were having it out. And so I don't have her information. I was literally in Target with my daughter and she stopped me. I didn't recognize her. She recognized me. And that's what she disclosed. I don't have her information. I don't have her number. I can't call her. But she is a nurse as well.
When did she disclose this to you?
This was the beginning of this year.
Okay, long time ago.
Yes.
Okay.
Which I take it, Dr. Brogy probably reached out to them a long time ago.
I don't know.
I mean, I don't know, but what I do know is that this trial happened a long time ago and we're not hearing about him until right before Thanksgiving.
Okay, you covered that point. But so what's your point about this mystery juror who I'm sure we could figure out her name and whatnot, but
I should be able to call her.
okay. And
That's true. Yeah, I should be able to call her.
to do what though? I mean, 606B doesn't disappear. It may be that it is more loosely applied if Dr. Brogy testifies, where you could say, well, you were a juror and this and that, but this juror you're talking about will come in and say, oh, let me tell you about deliberations. He was angry about this and that.
Not necessarily let me say about the deliberations, but she would be able to help with the impeachment of him as far as his biases towards Mr. Poole. We also
And I want to make clear, when we use the word bias, someone who looks at the facts and says, I think he's guilty, does that make them biased? Or are you saying that this woman said, you know, he was saying things that I thought were inappropriate about Mr. Poole, I make this up, didn't like his beard and thought he must be guilty because that would be a bias that I think one could explore, but it's not a bias to look at the evidence and say, I think the state has met its burden. That's
right. Is that part. It's the part that explores their discussion outside of the evidence that was given.
okay. So anything else you want to add about this juror that you're telling me about?
I would really say that if he's going to be allowed to testify, I would ask for a certificate of immediate review so that we can, one, get into the basis of his testimony, but two, get some case law and some precedent on an issue like this, because it is nuanced in the fact that the law doesn't say that you can't do it, but it also doesn't say that you can.
Okay. Got it. I will think on this one some. How are we looking outside? Any jurors yet? No? Gosh. We will get an update from them. Mr. Miller, anything else you want to cover before we start jury selection?
As far, do you want to wait on motion in the meetings?
Oh, no, I'd like to talk about anything and everything, but I don't see any. You've got this just in
Yeah.
on the heels of saying the state files things late.
Well, I haven't seen any file on them. I'm sure they have.
I bet not.
Do you? No. The only other one would be, testimony that, Mr. Poole is referring to Mr. Poole as a driver in the case without that first being proved.
Hold on one sec.
Oh, I think they're here.
Oh, they are here now.
The papers will be here.
Okay.
They're for board.
He just looked at, because just funny timing, like 30 seconds ago, I said, no jurors? Nope. But he just popped out, so he'll get that. All right. Don't refer to Mr. Poole as the driver until it's proven? Doesn't that mean we have to get a verdict and then what, they can go and tell the jurors, yep, he was the driver?
Essentially, Your Honor, it's our contention that, well, it's not contention, like they have to be able to prove each element of the indictment. Part of that is identification. And so for them to state that who is the driver before they've been able to identify him as the driver, would be improper. It would be, we will argue that it would be assuming facts that are not in evidence, unfair under 403 and an improper opinion under 701. The biggest thing in this case is who was driving the car at the time of the chase. And so it's an ID issue. And so for them, they don't have a single witness that can say, I saw Mr. Poole driving this car. They don't have that. And because of that, it is a question for the jury and shouldn't be just, the jury shouldn't be hearing it over and over again. The driver is Mr. Poole, the driver is Mr. Poole, have this repetitive nature of it. And then when they go back to the deliberations, they're still remember the driver is Mr. Poole, the driver is Poole, because it hasn't been proven. And so, we would object to that conclusion, in reference to Mr. Poole as being the driver.
Okay. Any other motions?
There was a picture, of a previous accident where Mr. Poole's car was on a pole, that was brought up during Mr. Poole's, cross-examination. We would object to the relevance of that. It's from a.
Oh, I'm remembering now. Was it the same car? There was some, I'm gonna call it a wipeout, and the car was sideways or something. There had been an accident.
That's correct. We would object to that coming in. Not relevant.
Okay. Anything else? All right. I am going to let the state refer to Mr. Poole as a driver. That is something they have to prove. But to me, that falls in line with referring to someone as a victim, when in the end, the state's going to have to prove that something wasn't self-defense, in which case it's not a victim, referring to the defendant as the defendant, the accused, a murderer. The state has historically been allowed to do that in criminal trials. I will make plain, as I am confident you will too, Mr. Miller, that nothing is settled until it's proven beyond a reasonable doubt. But the state's theory of the case is that your client was the driver and they can refer to him as that. It doesn't make it so just because they say it. What about, Mr. Body, this photo of the car on the pole? And to be clear, it's not balanced atop a flagpole. I think it is on its side or somehow has collided with a pole. Do you intend to use that outside of cross-examination of Mr. Poole if he testifies?
No, that was the only that I used it in the last.
Okay.
It became relevant based on an answer or answers that Mr. Poole gave, during cross-examination.
Okay.
Uh,
That to me seems the only way it would be relevant, unless Mr. Miller says some things in his opening. So I'm going to reserve ruling on that, Mr. Miller. It depends on whether Mr. Poole testifies and how that testimony goes. But if Mr. Poole is talking about a spotless driving record, then that photo is sufficiently relevant that it will come in. I don't remember the specific context when it came in, but it strikes me as appropriate impeachment material on cross-examination, but not affirmatively through other witnesses. Hey, do you remember when this happened to Mr. Poole? That wouldn't be appropriate. So we'll see if that situation arises again and assess it then. Okay. Mr. Abadi, any in limine motions from the state?
One, just recently learned, during the prior trial, Joseph Connors, who was the EMT, testified. The investigator working on this was able to recently confirm that he recently has passed away.
Sorry to hear that.
So the state under 804 E1 showing that he's obviously unavailable due to his death under 804A would be moving the court to allow the reading of his prior testimony into the trial, due to the fact that obviously both sides have the opportunity to question him as required by the body.
Okay. This is new to me and to you, Mr. Miller, so I'm going to think about it a little bit. But that does seem to be one of those scenarios when prior testimony can come in, when the witness is deceased but was subject to cross-examination here, not just by anyone, but by you in particular. Your thoughts about that?
Yeah, Your Honor, we actually found out about this back in April. So it's not new information. We passed it in January.
Well, it's new to me.
Yeah, but to that point, the only testimony that Mr. Connors, the only reason that Mr. Connors was called was to impeach him, because if Your Honor remembers, he's the only witness that had no firsthand knowledge of this accident, did not recollect, did not recall anything. And so I think it's improper to impeach a sheet of paper.
Well, I guess what I need to do is look at his testimony. So we're going to take a break in a minute. Sounds like folks are here. Oh, I got some paperwork here. So maybe it's not for you. Maybe Ms. I think she's doing that now. Yeah. I don't think she would have given me the only ones. So I'm guessing she's making copies. So I'm going to talk with Ms. Rivers about whether there's a transcript of his testimony or how we might get that. I'll need to see it to assess your concern. If he was called only to then impeach him. You have it. Okay. Well, then that means, is it in the docket? I mean, okay. There were a few excerpts in the docket, so I'll find it. And
I'm sorry, I'm trying to create people.
Yep. We're good. And I'll take a look at that.
Oh,
All right. If there is nothing else, you all can be at ease. Mr. Poole, if you ever need to use the restroom or something, we don't need to stop the proceedings. You're welcome to step outside and do that. We will take breaks between each jury panel. But because we've got two lawyers on both sides, a lawyer or you are free to get up to use the restroom if you need to do that. And we'll just keep on doing what we need to do.
Go ahead.
Yeah, you guys get situated, know that the 51 will be sitting there.
This isn't more of a motion or any type of motion, but just for the court to know, and I'm not sure if the state is aware of this, but there has been a lot of social media back and forth about this with the families of Mr. Minor and Mr. Jones contacting some threats against the witnesses, a few of the witnesses that we had. When they do testify, I would ask that maybe we have more of their presence of law enforcement. At the last trial, there was a fight that occurred at the that American Deli right there?
Here's American Deli is right outside.
There was a fight that occurred at that American Deli.
Okay.
And we brought that to your honor's attention as well. But just when we're presenting our case, I would just ask that my witnesses can have a little bit more.
Sure. So remind me, and in particular, liaise with Deputy Gordon. So when you know, like if you're calling a nurse, I don't think we need extra setup. But if it's a witness that you know is going to be combustible for people who may be in court, if you let him know, I don't want to suddenly bring in 9 deputies into the courtroom. That wouldn't be appropriate because then the jurors are going to say, what is it about this witness? But certainly we can do things such as no one else leaves the courtroom until your witness lets you know, I'm in my car and I'm gone, that kind of thing. We can help manage in that way, but you have to let us know when it's one of those witnesses. Okay?
I'm trying to remember last time, did we put the monitors on the ground?
If you very carefully pick it up and put it on the ground, or you can lay it flat, you just need to not disconnect it. Sure.
Hey, promise you, if we did.
It's something.